Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the November 2022 edition of the Third Fridays podcast. I can't believe it's already November, but we're at the end of the year, and we're going to talk a little bit about a Court of Appeals case that has a very, I don't want to say tortured history, but it's been going back and forth at the board level and the appellate division and now the Court of Appeals. And we're going to go in depth about each level and then talk about what we think is going to happen next. If anybody missed last month's episode, my guest was Noah Pollack. We talked about the onboard PAR process, prior authorization request, and benefits, disadvantages. How are we looking 5 months into the process? And Noah had some very interesting insights on the benefits and disadvantages for all the stakeholders in that arena. But my guest today is Janis. Welcome to the show.
Hi.
So, Jeremy, I guess touching on that PAR process, you've had a lot of experience dealing with some of these requests that providers make and our clients' responses. What has been your experience, or what kind of takeaways do you have with this process, going forward?
So a few things I've noticed. First of all, a lot of the doctors never end up responding when the first level or the second level reviewer provides a response, meaning that there's no jurisdiction for the court or the medical director's office to actually review the request.
How do you think that is? Because I agree, right? That the provider makes a request, it gets denied at either level 1 or level 2, and then it stops. Like, why do you think that's happening?
I don't think that the doctors actually understand the process well. I think for a lot of them, it's easier to just submit a new request. And actually, what I'm seeing a lot is that they do end up submitting new requests over and over again. It's the same thing they used to do with the MD2s when they were just MD2s.
Right. And I guess with the MD2s, now you bring that up, it makes me think about the people who are requesting reviews of those variance denials were claimants' attorneys, right? They were requesting review from the board or the law judge to talk about the denial. But that's not really an option, right? It's almost keeping the variance or the PAR out of the trial court and making the doctor have the onus of instituting. So that's an interesting look at it, because if you're right, if they're not in tune with the process, then they're probably just going to do nothing, or maybe file the same request that's going to get denied.
Yeah, I mean, the other thing I've noticed as well is that it's a little harder to file based on jurisdictional issues or issues related to the status of the case. There's drop downs specifically for the administrators to use, and it doesn't specifically apply to certain situations in certain cases.
Okay, yeah. Well, before we get too deep into the PAR process, I guess we could have another episode, but let's talk about this case. It's very, very interesting. The Court of Appeals came out with a decision on October 27th, so we're less than a month old with this particular opinion. And the case is Green versus Dutchess County. We have a very, very interesting procedural history. So before we get to the actual opinion from the Court of Appeals, let's start with going back 10 years. And we have a case that's established for the right leg. And in March of 2012, there's a finding of a 51% loss of wage earning capacity with a compensation rate of $500 per week, indicative of reduced earnings. Now, I know that many people who are discussing this opinion are going to go straight to the Court of Appeals and the appellate division and talk about the things that we're going to talk about. But I'm really interested actually at the outset as to how this right leg became an LWEC claim. Like, what type of leg injury do you think had to have happened to this unfortunate claimant to get a loss of wage earning capacity award?
I'm assuming it must have been something catastrophic, meaning maybe a machine hit the claimant's leg, caused some kind of injury that really made it hard to walk.
Right. That's definitely how it had to happen, right? Because usually it's going to be resolved in a scheduled loss of use. But the reason why I've talked about a reduced earnings rate is that he's working, right? So what type of catastrophic injury makes a claimant eligible for LWEC, but then also says, well, you're working? It's very, I just don't think many people are really talking about that aspect of this case, right? They're almost juxtaposed differently, where a right leg injury doesn't take the claimant out of work completely, but is so catastrophic that it's not resolved in a schedule. Is that, I don't know, I haven't seen that too often.
Perhaps if it's just doing a sedentary type job when you return to work.
That's possible. Yep. That's a good point, right? If we have a light duty position that doesn't really involve him using the leg, maybe because he can't use the leg, because of the accident. Okay. All that aside, 6 years go by, he's getting that compensation rate. And a 51% LWEC really entitles the claimant to 350 weeks, right? So on March 12th, 2018, the claimant, who is now the decedent, unfortunately passes due to a cardiac arrhythmia, right? Now, cardiac arrhythmia is not established on this right leg claim. So it's very clear, no one's arguing that this cardiac arrhythmia is related to the accident. So in the normal course of events, what would happen if that were to occur in a claim today?
You would just suspend benefits and you'd be done.
Right, because it has nothing to do with the accident, and it's, even if it did, the resulting benefits thereafter would be part of the death claim. Right? Right. It wouldn't be part of an accident claim. So the law, at least it seemed at the time, was very clear that no benefits were going to be passed to any surviving beneficiaries. Interesting argument advanced by the claimant or the decedent's attorney here, where they ask for what? What are they asking for with respect to the remaining LWEC award?
They're asking that it be given to the claimant's son, and essentially equivalent to a posthumous scheduled loss of use award.
Yeah, it's, the remainder of this LWEC award, they're asking for all of that money to be passed down. And despite all the case law that separates scheduled loss of use and LWEC, I have to think, what is going through their mind? Are they taking a shot in the dark? Because they have to know at this point that, is it like, what do we have to lose kind of thing? What do you think is going through their minds when they're making this argument before a law judge in June of 2018?
That they see the posthumous slew is there, which is also dictated under 15.3W as well. And they view it as, okay, if we're entitled to this award after death, the claimant's found at, MMI, perhaps it should be the decedent's survivors should be entitled to the remainder of the LWEC award.
Yeah, I guess, are they thinking that they have a winner at this point? Like, let's put ourselves four years ago in June of 2020. Do you think they're walking into this hearing thinking that they have a winner?
Not necessarily, and I think maybe perhaps they're looking at the bigger picture here and trying to say, if we are able to do this and are successful in arguing this, we're going to open up a door to a whole new classification or type of benefit.
That's a good point, right? Like their names would be forever etched in stone as the law firm that really uncovered this. I'm sure that would be a big feather in the cap for them. But what happens before the law judge in June of 2018 when they make this argument?
The law judge finds that there's no awards, or the decedent's survivors are not entitled to awards past the death date.
Right. So they lose. And for all intents and purposes, anybody in June of 2018 that would be looking at that decision is being like, that makes sense, right? That makes sense. There's really no provision that specifically allows for it. And it's not like Section 15 was crafted yesterday, right? They appeal. Claimant appeals to the board panel. And in January of 2019, what does the board panel say?
They affirm the finding of the law judge.
It's fairly simple, right? The board panel says this is not the type of award that gets passed down to a surviving beneficiary. It's not a posthumous scheduled loss of use that you referenced earlier. And they make the clear distinction that an LWEC award is not a SLU award, right? A SLU award compensates someone for loss of function, whereas an LWEC award compensates someone for their earning capacity or lack thereof. So the difference in the award gets to the heart of how the board panel makes a decision in January of 2019. And I want to think about, let's say we were, doing what we do on the employer side, and we look at this case and we say we want to appeal. Let's say that it was against us, right? Let's say the board panel finds in favor of the claimant there. What type of analyses are we providing to our client to determine whether we're even going to the third department of the appellate division as the next step?
First thing we usually do is a cost benefit. So how much in benefits would the decedent survivors be entitled to?
Right. So if we look at it, what would we be going based on this type of case?
No, because the claimant was only entitled to 38.8 weeks of benefits at that point, 500 a week. So the total value is less than 20,000.
Yeah, I feel the same way. I guess it would depend on really some of the big picture things that you were talking about. Like, for instance, that particular client may look at $20,000 exposure versus the cost of going to the appellate division and say, well, we have to pay the $20,000, and then if we go to the appellate division, that's another cost. And then what's our recovery? Even if we win, we have to litigate, reimbursement for the workers' compensation board and the Section 151 fund. And so if we lost and we had to pay this, I feel like our client would need to be in that big picture mode that you were talking about. It's like, I don't want this to be a thing going forward. So it's a very interesting, interplay here, where here you have this, at the time of death, a minor child who is now getting older and older. He's not just getting an award here. He's not getting the award. He'd be requesting the award, and we're now outside the fee industry of a workers' compensation administration hearing where the attorney's fee is based on the award received, right? He probably has to pay or maybe convince his father's attorneys to do this for free, right? I mean, it just seems like at $19,000, is that enough to go after it if you don't have the case law and you have to pay extra as a minor child?
It would be worth it, but I see it as the attorney was probably the one that's pushing this issue.
It's possible, right? Because if it is a big picture thing, then maybe they are willing to do it for free. So we think it's just, okay, this is a normal case. The appellate division is going to shut it down. But in March of 2020, the case turns on its head, because obviously if it didn't turn on its head, we wouldn't be talking about it in a podcast. So in March of 2020, what does the appellate division do with respect to this case?
They overturn the case, and they state that LWEC and scheduled loss of use are both under 15.3.
Yeah.
They're both dealt with under 15.3, and they're therefore equivalent.
Right. It's this weird situation where they say, well, scheduled loss of use and loss of wage earning capacity is the same because they're contained within the same section. And despite all the things that we've already talked about, how different they are, they use this idea of fairness. And they say that it would be so unfair that a person who passes away would not be able to move an award to surviving beneficiaries, but someone who has an LWEC award would not. And as soon as that happens, I feel like the wheels are turning to get that overturned. Once you're like going towards public policy, there's now a chance that this might not stick. But the weird thing is that they relate this idea of fairness to what happened in 2007. So a little bit for our listeners, history in workers' compensation in New York. In 2007, a permanent partial disability now became a capped award. Whereas prior to 2007, if you had a permanent partial disability, you would have benefits forever, whether that was a 1% partial disability or a 99% partial disability. And the legislature made a very, very good decision to cap awards if you have a partial disability. And because they did that, the appellate division now looks at LWEC versus SLU, and they say, well, the legislature intended for both of them to be equal because they're making these LWEC awards capped. And once you make that jump, like I said, I think you're just setting yourselves up to be overturned. It almost just invites some analysis from someone else. Any thoughts on that, Jeremy?
I believe so, because essentially they're trying to change public policy. They're interpreting it in a way that doesn't necessarily match up with what they intended to do in 2007.
Yeah, you're right. And so we get to, the April of 2021 decision from the Workers' Compensation Board, because basically appellate division, as they do time to time, basically say, no, Workers' Compensation Board, you got it wrong. So it comes back before the board in April of 2021, and perhaps maybe it's just me and my dislike for some of some of these board decisions that I look at this decision and almost chuckle a little bit, because it says the board is constrained to find that claimant is entitled to an award in the amount of 38.8 weeks of compensation at the rate of $500 per week. So the board basically then uses the appellate division to rubber stamp whatever that decision has and directs the carrier in this case to pay the $20,000 in exposure to the decedent surviving beneficiary. And I don't know, maybe it's just the note that I make because I'd like to talk about it, but I just specifically wanted to define constrained for our listeners. And the dictionary definition was appearing forced or overly controlled. And I guess when I look at the writers of this board panel decision, I'm wondering, they're probably not happy about this, right? They're not excited that the appellate division has overturned their decision. So is it something that maybe the board is worried about for future cases, that they're writing this opinion like this?
Mm-hmm. The only time I usually see this language is when a law judge feels you get an overturned decision from the board panel, goes back to the law judge, and they feel like they have no choice but to do something, whether it's a fraud finding or something else.
Right. So yeah, that's a good analogy where basically, maybe even at a lower level of administrative appeal, the law judge is overturned by the board panel, but then has to hear the case at the trial level again and has to implement a board panel decision that he or she doesn't necessarily agree with. So here we are in 2021, and we're thinking that as employers, we've now been opened this can of worms that is going to create so much exposure down the line. But then we get to October of 2022. This is just last month, and the Court of Appeals reverses. And again, if they didn't reverse, we're not talking about this, right? We're probably just talking about this in 2021 and moving on with our lives. But 2022 hits, and the Court of Appeals turns it on its head again. So anything about this Court of Appeals opinion, Jeremy, that you thought was particularly interesting, or how can we summarize it for our listeners here today?
So I thought the interesting thing is that they essentially state that the Schedule S, you use the word, is essentially statutorily, like what rate of benefit the claimant is going to receive for a certain period of time. In contrast, they specifically state that a non-scheduled award does not entitle to the claimant to weekly compensation benefits at a specific rate over a set period, because the rate and duration of benefits awarded by the board may change from one period to the next. Especially in a case like this where the claimant's receiving reduced earnings, it was specifically based on what the claimant was earning outside of the case.
Right. Like, what if, for example, the decedent passes away in March of 2018, right? But what typically happens in a reduced earnings case is the tax returns get filed at the end of the year, and then a reduced earnings award is modified and then prospectively changed based on what the claimant is earning at that time. Because at a 51% loss of wage earning capacity, if, for example, the claimant started making more money, which, from 2012 to 2018, most people will be making more money than they did 6 years ago. So in theory, it's interesting that the reduced earnings rate never changed, but it could have. And the board panel, or not the board panel, the Court of Appeals is looking at this from, like you said, a statutory construction point of view, where they're saying that this non-schedule injury is dependent on the claimant's actual earnings and a continuance of disability. But a scheduled loss of use is not, right? The scheduled loss of use award is supposed to compensate you for loss of function, right? The range of motion, any special considerations you have. And it's payable all at once, right? At the claimant's election. And so what if, because now the mad scientist starts thinking about all this, what if the claimant elected to have his scheduled loss of use award payable weekly? Would that change things?
Based on their analysis, I don't think it would, because I think what they were talking about is that we know the set amount the claimant is entitled to. Whether it's paid out over time or a lump sum is irrelevant to that.
I agree too. I'm mostly asking that question facetiously, but also what claimant is going to take a weekly award thinking about this 6 years in advance. No claimant's going to take that when they could have it all at once, tax-free, with no discount value attached to it. So the Court of Appeals reverses, and then at the end of their decision, it's again, we're talking about a higher court looking at a lower court and deciding something in opposition to them. But then, for the heck of it, let's just talk about their analysis and why it's wrong, which is really funny to me as a law nerd, where they basically say that the appellate division's analysis of the 2007 legislative changes is not the right analysis to make for this case. So, the appellate division concluded that despite the award's differences, the legislative intent to achieve parity between the two types of awards manifested by the 2007 amendments required the awards also be treated similarly in this context, believing that the alternative holding would effectively perpetuate the very unfairness the legislature sought to eliminate. And when you think about this, a court is looking at legislative intent and extending it. And the Court of Appeals is saying, no, appellate division, you can't do that. This is not the same type of structure, because the legislature has the opportunity to make scheduled loss of use awards and LWEC awards equal. They have not chosen to do that. They're just trying to do a whole bunch of things that are before the governor's desk that we've talked about in earlier podcasts, but they haven't done this. This is such a fundamental part of permanent disability, scheduled loss of use versus LWEC.
The other part of it that I find interesting is they talk about for 100 years, there's been a distinction between the two, and you can't just change it based on the way you interpret 2007 Amendment to read.
Yeah, I always think that's like a funny tagline. Like, everybody knows when these, you could research when these sections were enacted, but when a court says more than 100 years ago, it's you know that the appellate division is getting the proverbial spanking, I guess, that their analysis was not correct. That there's no distinction between, or that there is a distinction between schedule and non-schedule, so you can't just make them equal. I would imagine if the appellate division decision were to stand, then schedule loss of use and non-schedule awards would then all of a sudden have these appellate division opinions that would start making them closer together without any legislative change. So now we have a case where the law judge from 2018 is now vindicated and justified in 2022. So where do we stand right now? Do you think the legislature could make a change to this type of thing to prevent this litigation, or are we going just back to status quo? What are your thoughts there?
I believe it's going to stay at the status quo. I believe they're focused more on the legislative changes that they proposed over the last year than something like this, which has a long-standing history.
Yeah, it's you're probably right. When we look at this Court of Appeals opinion, the amicus briefs were filed by the New York State Insurance Fund and the Injured Workers Bar Association, where you have these interested parties really spending time trying to create or defend case law, right? And whenever that occurs, I think that courts are more inclined to just keep decisions as is. I think the appellate division took a step too far because there's no basis for calling a scheduled loss of use award and an LWEC award the same. And the Court of Appeals really hammered this point home that they're entirely different. But it begs the question, scheduled loss of use and LWEC, why should they be different? What if you have a major shoulder injury, but you only have a 45% scheduled loss of use, meaning that you can't pursue LWEC? But then you have a back strain that's healed, so to speak. But your vocational factors or your functional loss means that you have a 1% loss of wagering capacity. I've always thought this to be unfair, that it just gave claimants the choice of whether or not they would pursue one award or the other if they had scheduled and non-scheduled together. I think it's kind of odd that the body part dictates what type of award you get, because there are many people, claimants that we deal with every day, that have these major knee injuries, major shoulder injuries, but they're not eligible for a loss of wagering capacity award. Yet someone gets a little ouchy in their neck and they're eligible for a very long-standing award that's very hard to take credit for prior payments.
It is somewhat arbitrary, but I think the legislature has tried to deal with that by having certain special considerations, allow for classification in certain limited circumstances.
Yeah, that's a good point. It's the legislature really hasn't bended that way. But who knows, maybe in a year or two, the United States Supreme Court will hear this decision. I'm just kidding. That would never happen. But I think it's been a good discussion, Jeremy. Thanks for coming on to the show. Any final words for people looking at this decision to think about, in terms of how to deal with unrelated death instances, capped awards? Any final thoughts for our listeners here today?
I would say look at awards, or look at any type of capped awards. If the claimant's going to die, look at it with a skeptical eye. Be aggressive as you can.
Right. If the claimant's going to die, then it's, you're really looking at it from a relationship point of view. Is this related to me or not? And then use what's in front of you to really dictate how you handle it. I guess from that early period, from March of 2020 to October of 2022, there was a really, really weird part of the law where we were in, where if that death happened between those 2 years, we had a big problem on our hands. But now that the Court of Appeals has come to the rescue and put some logical sense behind their decision, I think we're safe for now. All right. So for Jeremy, Janis, my name is Christian Cisan, reminding you to defend from day one.